docket. That is case number 114682, State of Kansas v. Dustin Hilt.
Good evening, Your Honor. My name is Randall Hodgkinson. I'm appearing tonight on behalf of Dustin Hilt. I request 3 minutes for rebuttal, please.
3 minutes is granted.
Your Honor, this case is a fairly unusual posture for me in that we don't have any guilt issues in this case because Mr. Hilt's conviction for first-degree murder was affirmed in your prior appeal, and this is Mr. Hilt's second trip to this court. So the only issues we have to deal with are the procedural issues related to the remand hearing for determination of whether aggravating circumstances are required, giving a hard 50 sentence in this case, or whether Mr. Hilt should have gotten a hard 25 sentence. So we raised 3 issues in this case. Your Honor, I have comments on the first 2 issues, although the court may have other questions on the 3rd issue. And because my comments are fairly brief on the 2nd issue, I think I'll start there, which has to do with a claim of prosecutorial error or improper argument in this case. And the particular claim has to do with the prosecutor telling the jury or encouraging the jury to determine whether a hard 50 sentence was appropriate in this case. Now, as I just said, obviously the facts that are being found by the jury in this case are relevant, maybe even determinative of the ultimate question of what sentence does Mr. Hilt receive. But it's not the jury's job to decide what sentence he gets in this case any more than it is a jury's decision in any other case that we decide outside of maybe capital cases.
How is that true? When it's, you just said required, whether the hard 50 was required. I mean, there is no trial court discretion to refuse, provided the verdict is not queered by some outside factor. Once it's accepted in one of these proceedings, then the hard 50 is mandatory, is it not?
The statute, I believe the statute requires it.
Right.
And we haven't argued anything about that statute in this case.
And given that, isn't it an accurate statement that when this case went back, the jury's job was to decide whether the hard 50 or the 25 were going to be?
No, the jury's job in this case, just like in any other criminal case, is to decide whether the state proved its claims beyond a reasonable doubt. In this case, aggravating factors. And in this case, whether those aggravating factors outweigh mitigating factors.
And they were told that. They were told that very clearly, that that was their job by both the court and the prosecutor, right?
At least by the court. I can't speak. I'm not saying the prosecutor didn't, but.
Yeah, I think that's what the record reflects. But this summary statement is still reversible error.
It changes the dynamic in that it moves away from what should be clear. And there were instructions given in this case regarding the elements, but it's our claim that this kind of statement dilutes them to say, it's sort of like, well, you know, do justice, do what you think is appropriate. Appropriate is the word they use. What's the appropriate sentence in this case? And that's not, even still, that's not the jury's job in this case. Perhaps the legislature made that judgment as to what's appropriate. If certain facts are found beyond a reasonable doubt, then the legislature, I guess, has said this is the appropriate sentence for this.
Was there any discussion during voir dire? I mean, this you're right. This is a little unusual. Like there's a jury selection process, and then there's really kind of a trial based upon whether there's proof beyond a reasonable doubt that there's aggravating factors. During any time during the jury selection, were the jurors informed about what they were there for? I mean, wasn't the hard 50 discussed as this is why we're here?
Your Honor, the answer to your question is I don't know whether it was discussed during voir dire, although I think the record shows, even in instructions, the jury was probably told that's the purpose of this proceeding is ultimately, you know, to decide, so as any criminal case.
Right. It's no mystery that finding aggravating factors was going to result in a hard 50 sentence being imposed. The jury knew that.
As far as I can tell, that's right.
That was part of the discussion. That was probably throughout this entire procedure, because that was the purpose of it.
I think that's right, Your Honor. I don't have any basis to contest that.
And given that,
But-
how is Mr. Hilt prejudiced by this statement?
Because to the extent that the prosecutor's comment in this situation relieved the state of the burden to do what the jury's really supposed to be doing, not determining an appropriate sentence, but determining whether or not the state proved its claims beyond a reasonable doubt. To the extent that they did that, it's diluting the burden of proof, and that's the prejudice in this case. This wasn't overwhelming evidence. The defendant argued that there were mitigating circumstances in this case, and that those mitigating circumstances were substantial. And it's our argument that the prosecutor's comments in this case diluted our ability to make those arguments in a fair way.
What counteracts that a bit is that the jury went beyond the verdict form, marking a box, and actually wrote a narrative and explained their verdict in terms of why it was heinous, cruel, and atrocious. So that sort of negates the your suggestion that it was a nullification kind of thing, or it was a emotional thing, because they voiced it in terms of what the test was and what they determined.
They rendered the verdict and had that additional information, but it doesn't change that if they did that through a process where they didn't understand that they had to find those elements beyond a reasonable doubt because of the prosecutor's comments, that would result in the denial of the fair trial for my client. The first issue in this case, Your Honor, had to do with the removal of a juror, juror number 7 in this case. Ironically, the second time this happened to Mr. Hilt, because this same issue, a similar issue, was raised in his guilt phase trial.
How are the juries getting that smart?
I'm sorry, Your Honor?
How are the juries getting that smart in Johnson County that they know they can get rid of a recalcitrant juror by claiming misconduct?
Yeah, I don't know how how well that's known. I assume it's just a coincidence in this case that it happens twice in the same with the same defendant. But Your Honor, I did want to make it clear that the judge in this case found that the juror had violated the admonition because he had gone, apparently, because the juror was, my client was just over 18 when the incident happened in this case, and apparently the juror in this case was of reasonably the same age, and recognized during the discussions that, maybe we went to the same high school. And to satisfy his curiosity, I think it's undisputed, he admitted, I went and looked in my yearbook, and yeah, I found his picture. I didn't find anything substantive about him. I didn't find anything about this case. This yearbook and the photo was from years before anything happened in this case. I was just curious whether he was the guy, a guy that went to my high school. And the answer is yes, and that was the end of it.
He actually went to look for the girlfriend first, didn't he? He went to look for the new girlfriend first, didn't he, or something?
It might be.
Yeah, and ended up with the defendant as well.
Yeah. The critical part of it they talked about mostly, and what the other jurors talked about was him relating that he found.
Could that not have some bearing on this case? Because wasn't she a witness? She was a witness as well, wasn't she? And if that's a person you went to look for originally and discovered they were together in high school, I mean, does that not lend some credibility to her testimony?
I mean, I can't imagine it would, Your Honor. And as I reviewed this case and thought about it getting ready for argument, all the cases that I've seen in voir dire, especially in smaller towns where, you have jurors, and a lot of times, do you know the defendant? Yeah, I went to high school with them. Mm-hmm. That doesn't make you ineligible to be a juror. That doesn't give you pre-knowledge of this case in some way.
It wasn't, but isn't the misconduct the violation of the admonition, as opposed to whether it was worth anything to go do the research? Because he was told very clearly and repeatedly throughout the trial, don't do this. Don't do everything you need to decide this case you're going to hear in this courtroom.
Your Honor, I would respond that he was told not to research about the case. Don't do internet research about the case. Don't go to the scene. Don't do anything about this case. Don't learn anything about this case. Everything you're going to need to know about this case, you're going to learn in here. And we would argue he didn't. that this was not substantive and was not material in any way to this case. It's not like it was an identity issue where, you know, I'm going to use this, I think I can identify him by my yearbook.
Well,
There wasn't.
Did he violate the admonition or not? I heard.
No,
I heard
we
you
don't believe he did.
Okay, but you started out by saying, well, we admit that he violated the admonition because he
No,
admitted it.
We admitted that he went and looked for this photo in the yearbook. I'm not admitting that it's a violation of the admonition, but even if it was, it still wasn't a material violation in any way that justified kicking him off the jury.
Would we have different standards of review for those two different questions? In other words, if there's a factual finding that an admonition was violated, and you're asking us to review that finding versus what probably is just an abuse of discretion standard on whether removal is appropriate. Would you agree with the way I just sort of laid that out?
Yes.
So which is it, or is it both?
Yeah, but, you know, and I also realize I'm confined to the arguments that are made. But in answer to your question, certainly I think about materiality usually being a legal question. And to the extent that the question of, you know, even if there was a violation, was it a material violation, I think could be illegal. I would argue it's legal, but I don't think that's a well-developed argument in the brief. So
I think it's materialities need de novo, isn't it?
Yeah.
Yeah, in the 455 analysis.
in relevance, yeah.
Yeah.
As a follow-up to your discussion with Justice Beyer, who was suggesting it wasn't just a possible, in your view, violation of the admonition, there were other things. And my understanding is the state has argued, and he'll probably get into that, but I want to give you a chance to discuss that now. Mr. Thompson had violated the admonition, which had been given many times. He acknowledged he understood the admonition, yet still violated it. He initially only admitted to looking at the picture, but after more questioning, he admitted to looking at a witness's picture. And after making the statement to his fellow jurors, he denied it when they confronted him about it. And my understanding is the court concluded from this that this person was not reliable and not to be trusted, and for this combination of reasons should be discharged. So what would be your response to that?
To whether the judge's findings in that regard? Two things. One, I don't think it's well supported by the record in this case, because the juror in this case said, I didn't think I was violating any admonition. I understood I wasn't supposed to be researching anything about this case, listening to any media reports like the juror in the first case. I didn't. I just was curious that I thought maybe this person went to my high school, and it doesn't have anything to do with this case, so he didn't think he was violating anything in that regard. With regard to the sort of concerns or claims about his trustworthiness, there are two answers to that. One is, I don't know that that's, respectfully, I would say, I don't know that's the district judge's business. I mean, he has a jury. The only questions the judge has is, has he violated the order in a material way or is otherwise incapacitated or unable to serve as a juror? And when asked, the juror repeatedly said, I will be, just like jurors do in voir dire all the time, said, even if I do know something about this, I will only decide this case based on the evidence brought forth in this courtroom. He was able to continue as a juror, and the judge had no basis on this record to dismiss him.
Did I read the record correctly? He was also the foreperson?
That's right, Your Honor.
All right, thank you.
Your Honor, my time is up.
I have one more question before we let you get away. So let's assume error on the striking and the replacement. Convince me there's prejudice, because all I see in the record is an assertion by counsel of information gleaned post-trial, after all of this happened, post-verdict, from some conversations with jurors. And that was not in play. That was specifically kept from being in play when the judge was interviewing all the other jurors and determining whether this person had to go. So convince me that there's prejudice here on the record we've got before us.
Sure. So I think the answer is you have to decide, what is it that you would have to see in a case like this to establish prejudice, particularly given the extremely, the dilemma that the district court is in when dealing with a situation like this. Because as I think is required, the district court was being very careful to say, I don't want to know about the state of your deliberations. Because I think this court and other courts have noted that if well, for example, if a judge said, well, you're just holding out, I'm dismissing you so that maybe we can get to a verdict, that would obviously be inappropriate. And so we're not going to find out about the state of your deliberations. So it's going to always be very difficult, Your Honor, to sort of make the record of whether, sort of the affirmative record of there being prejudice.
But not impossible. I mean, it's done. This is the way jury misconduct cases arise. The lawyers talk to the jurors afterward. They find out there was something inappropriate that happened, and they get an affidavit. We don't have that.
I don't have an affidavit, but I do have the attorney on the record saying I talked to the jurors and this is it. The judge in this case found no error.
Right.
And so didn't develop that record. And I suppose, Your Honor, if you said there's error but we don't have a record, that maybe appropriate disposition is remand it and call the jurors in and ask them. Because, you know, we have some evidence in this record. I don't know what else I can provide. I can't provide anything else from this record, is certainly my answer.
Thank you, counsel.
Thank you.
Mr. Chief Justice, and may it please the court, I'm Jacob Gonteski. I represent the plaintiff, the appellee, the state of Kansas in this case. Dustin Hilt received the appropriate sentence for the crime of murder when he and 3 co-defendants brutally murdered Keely Allier by beating her and stabbing her to death while she begged for her life. And then they dumped her body in a remote area of Cass County, Missouri. We were back in the district court when Mr. Hilt's case got remanded because he had first been sentenced to a hard 50 by a judge. When the case was remanded, a jury heard his case this time, and the jury heard what they needed to hear to impose the hard 50. The fact that the prosecutor stated to the jury part of their task is to determine whether or not it was appropriate to impose the hard 50 or a hard 25 was an accurate statement of the law. It was not misconduct or error in any fashion, any more so than it would be for a prosecutor to tell a guilt-phase jury, you're here to determine whether or not the defendant committed this crime. That's not the ultimate test that they utilize to establish guilt. They have to examine the elements and determine whether the state proved those elements beyond a reasonable doubt. Just like in here, although the ultimate test that the jury did not utilize, their question was not, is it more appropriate for him to spend at least 50 years in prison before he's granted parole or not? They were given a test to answer that question, and the test was read to them by the judge. It was read to them by the prosecutor. It was talked about in voir dire. It was talked about in closing. And it was on the verdict form that the court already talked about, in which the jury elaborated in rare form. And Justice Johnson, you mentioned we have an interesting record here that we don't often have. And in this case, on the verdict form, the very entry sentence on that verdict form, which the jury spent a great deal of time on, states, we, the jury, unanimously find beyond a reasonable doubt that one or more of the aggravating circumstances have been established by the evidence. That was the legal test they had to answer. And that's the test that they utilized. So for the prosecutor to summarize it as whether or not a hard 50 or a hard 25 is appropriate was an accurate statement of the law. It was not error. If that was error, then it would be error in every case in which a prosecutor states you're here to determine whether or not the defendant committed this crime. That's a good summary of what they're there for. There's a legal test underlying that question. And that legal test in this case was utilized appropriately. There was no prosecutorial error. As far as the first issue of juror misconduct, that's an interesting issue which Judge Draghi paid very close attention to, in part because there had been the problem that arose in Mr. Hilt's first trial. So the court was keenly aware of the admonition that it needed to read to the jurors, and it repeated that admonition, not just the first day, not just jury selection. The court repeated some variation of the admonition during virtually every break. even a 10 or 15-minute break in the middle of the morning or the middle of the afternoon for restrooms before more evidence would be presented, the court reminded the jury of the admonition. And in so many words.
And what specific words would this act of going into his sister's bedroom, picking up a yearbook, a hard copy, didn't Google, he was told not to Google, he didn't do that, walked into his sister's room, picked up a yearbook, looked in there to see if he could find the witness, and in doing that found the defendant also. What specific words out of Judge Dragi's mouth would have led a rational, reasonable person to understand they couldn't pick up their sister's yearbook?
From volume 28, page 129, Judge Draghi said in various forms, quote, "Everything you need will be presented in this room." The yearbook was never presented in the courtroom. The judge also stated, do not Google anything. And Justice Johnson, you're absolutely correct that the juror in this case did not Google it. He found a hard copy. The state would argue in spirit that admonition is still violated. And furthermore, Judge Draghi stated, quote, "Do not do your own research. Do not get on the internet. Do not do anything." If that juror could not understand that those admonitions meant don't do anything outside this courtroom about this case, then there's not much more of an admonition he could have given that this juror would have understood. And so when this juror revealed this information to the jury, the other members of the jury, and they immediately paused and sent a note out to the judge and said, "We're concerned, we think there's a problem, we think somebody violated the admonition." This juror immediately backtracked and tried to rescind what he had stated.
That was 5 different jurors said that he tried to back off.
Right. And when he was called upon it, he first only stated, as you had earlier noted, that he had looked up one individual. When he was pressed further, he stated he found another individual in the yearbook.
So let's talk about the significance of that, because I'm intrigued by your opponent's argument that the judge is not supposed to be sitting as an arbiter of the character of the juror, that we don't demand of our jurors that they all have sterling character. We demand of them that they can be objective and fair and listen to all the evidence and make a decision.
Absolutely, we do.
So what role did that have here? Because the judge did mention more than once, I think, that this juror was not particularly forthcoming or forthright or words to that effect.
In every instance in which a party would move to excuse a potential juror for cause, the judge, the district court judge, is put in the unique position to assess that person's ability to hear that case, to assess not just their statements, but their credibility, the way they carry themselves, the way they present themselves in court. On a cold record, it's tough for us to review it at this stage, but the district court judge was in a unique position to be able to watch that witness, that juror.
So your answer to my question is that's an appropriate inquiry?
Absolutely, absolutely. And not only has Kansas said as much, but federal courts have said as much as well. The judges must have reasonable cause to remove a juror during the pendency of a case. And reasonable cause is a term that is often put into play in federal cases regarding jurors, and Kansas state cases have said when those terms are utilized, we should look to federal cases for some guidance. The federal case that I cited to out of the Ninth Circuit talked about a juror that was dismissed when, upon questioning about his activities, the primary reason he was removed was because the court found he was not forthcoming and he was not truthful in his responses.
I'm sorry, you said this is a federal case in your brief?
It is. I believe it's
Okay.
the Ninth Circuit on page 15 of the state's brief. And in that case, page 15 into page 16, United States v. Vartanian from 2007. In this case, we have essentially the same scenario. We have an instance in which a juror, while the argument can be made, did not violate the letter of the admonition. I argue he did, but I understand my opponent's argument that he did not. But in arguing that he did not, he could still be removed by the judge, even if he did not strictly violate that admonition, if he was called out by other jurors, and furthermore, if an impression is left by those other jurors that somebody's getting away with something they shouldn't while they're a juror, it creates immense problems with the whole credibility of the system. And it was within Judge Draghi's discretion to remove this juror when he found he was not credible.
And is that because the lack of credibility somehow, as my colleague was indicating, taints or otherwise undermines the confidence in that juror's ability to decide the case?
Precisely.
Or is it because the judge has made a credibility finding during a factual inquiry, and that credibility finding can be used by the judge in assessing whether or not the admonition was violated? Do you see the difference between the two that I'm positing?
I do see the difference, and I think both apply here. If the credibility finding in your second inference there is the crux of the issue, then it really would, to say that we must leave somebody on even if there's this credibility impingement upon him, then it really does away with the entire oath that the jury's going to take at the outset. Why have them take an oath to follow the law if while they're proceeding through deliberations they can violate it with no consequence?
Well, I guess I could pose the extreme hypothetical of a judge who comes to the conclusion that, well, I really don't think that you committed misconduct, juror. I don't think you violated my admonition, but in the course of this, I just don't think you're believable. So I'm just going to remove you for that reason alone. I mean, would you suggest that that was appropriate?
I think in certain circumstances it could be. I think that could rise to the level of reasonable cause to remove a juror if the judge is concerned about that person's credibility and their forthrightness when they come before the court in answering questions about their activities during deliberations. I think it could rise to that level. I don't think we have that here.
It has to have some effect on deliberations. Surely, I mean, just being a bad person. The judge doesn't just say, you know, I just decided I don't like you.
Absolutely.
You're out of here. I mean, that can't happen, right?
It can't, and I doubt that circumstance would ever come before the judge.
And what happened here? I mean, that was my original question, I think. What role did this really play? I mean, I think what I heard you say in answer to my colleague's question was that it matters because it undermines the ability of the jury to function.
Precisely.
And that would be bothersome. That
Right.
I get where that amounts to reasonable cause. But surely the judge doesn't just get to sit as arbiter of character, as I said before.
Not
in the abstract.
Correct. Not in the abstract.
Okay.
If a judge sees a juror sleeping during a trial, he's obligated to step in. He's obligated to do something. And in those circumstances, he does.
But in this case, there's nothing that the judge observed. Rather, it's the other jurors. And when this came up the last time we had this same issue, I had quite a bit of heartburn about the fact that you can have 11 jurors that want to reach a verdict and get rid of a holdout, can go to a judge, allege misconduct, and get them kicked off the jury so they can go home, so they can reach their verdict and go home. And it really shocked me to see the same thing come up in the same case again. And some people believe in coincidence, others don't. But my point being, shouldn't there be a real red flag when you have 11 jurors ganging up on one juror over what might be said as a borderline violation? We're not talking about being on Google. We're not talking about reading a newspaper. We're not talking about bringing a Bible into the jury room, the egregious things we see all the time that you're aware of. We're talking about walking in his sister's room, picking up the yearbook, and now we have the other 11 jurors playing tattletale to the judge. Shouldn't that be a red flag that maybe there's an ulterior motive to get rid of a holdout?
Well, Justice Johnson, where you see a red flag, I guess, that principle then would apply any time jurors go to the bailiff with a concern over the activities of one of their cohorts.
Well, for instance, in this case, I think there was an argument made that there's an implication that he talked to his sister about the case because someone asked if his sister knew the defendant, and he said no. If that was the speculation, I'm wondering why wasn't that brought up when you question the juror, why wasn't the juror asked, what did you discuss the case with your sister, rather than speculate and use that for rationale for the dismissal? You understand what I'm saying?
I absolutely do.
Yeah.
And let me state at the outset, I understand where the heartburn that you put, where that comes from. I absolutely understand why that would exist. But in this case, we don't just have other jurors who are pointing out this misconduct on behalf of one of their cohorts. The basis for this juror number 7's removal was not just what the jury told, the other members told the court. It was what the court itself observed when they called juror number 7 to the stand and asked him specifically about it. In fact, that really appears to be the cornerstone of Judge Dragi's decision to remove him, was the fact that he believed he was not forthcoming. He was not revealing the actual facts as they had occurred, and his credibility was really impaired by the fact that he wasn't being forthright with the court when he was called upon it, that he had backtracked with other jurors when they called him on it, and so on. So we don't just have 11 other jurors ganging up on a holdout. We have a court that very closely examined whether or not what this juror did was misconduct warranting removal. He didn't just take what the other jurors said at face value. He dug into it himself. Finally, I'd just briefly like to pay some mention to the last issue, which was pronouncing sentence. Mr. Hilt had already had the hard 50 imposed on him earlier. He knew what the hard 50 was. It was no surprise in this case when the hard 50 was imposed. And to make the argument that Judge Draghi did not, in so many words, tell Mr. Hilt, you are now sentenced to 50 years with the Department of Corrections before you have any chance of parole. He didn't use those specific words, but the sentence was actually pronounced. Judge Draghi stated in his words, volume 26, page 13, quote, "The jury has spoken. They have imposed the hard 50 sentence on the defendant. Then the court will impose that based on the jury's verdict." That absolutely was a pronouncement of the verdict in this case. When asked if the state had anything additional to add, the state said no. And when the court inquired of the defendant at sentencing and his attorney whether or not they had any further inquiry or statement to the court, they said no. Everybody in that room clearly understood that Mr. Hilt had been sentenced to the hard 50. And to say otherwise would really ignore the record in which he said nothing and he made no further inquiries of the court.
Does this process allow for allocution at any time?
I don't know if it does statutorily.
It wasn't brought before us, but does it? I mean, typically, a convicted person who's being sentenced has a right, absolute statutory right to an allocution. Do you know does this procedure call for it? And did he? I don't think he received one.
I don't believe he did. I don't believe he offered one. I don't believe he made one to the court at the time of sentencing, which was held at another day.
I understand, but this is a new sentencing. He was resentenced.
Correct. I think essentially, although he was not afforded that at sentencing, I think his time for allocution was in offering his mitigating circumstances that he made to the jury. That was his moment. That was his opportunity to offer mitigation and to seek leniency in this case.
Do we have any further questions? Any further presentation?
I'm out of time. If there's no questions, I have nothing further.
All right, thank you, counsel.
Thank you.
You reserve 3 minutes.
Your Honor, I just had 2 comments. One on the dismissal of the juror. I just wanted to note that the court in this case asked juror number 7 whether he could, to whatever extent he saw this picture, was that going to influence anything? He said, no, I'm glad to stay on as a juror. And the judge asked every other juror, does the fact that he did this, is that going to have any influence on your decision making here? And every one of them said no. There's just no record here to show that juror number 7 was unable or unfit to continue as a juror. My last comment, and it goes to this question about the prosecutorial argument, because I agree with my colleague that, was it an accurate statement of the law? Yeah, I guess. But I may have argued to this court once upon a time that we should be able to tell juries what the sentence is. It would be accurate. It would be an accurate statement of law in a felony murder case to tell a juror, if you convict him, he's going to get a life sentence. That's an accurate statement of the law. And yet, I don't believe I would be permitted to do that as a defense attorney, to let the jury know, here's the sentence this person is going to receive if you convict him. If that's true, it's just as true in this case, because that's exactly what the prosecutor did.
But not only the prosecutor, everyone knew it. It was just like my colleague Justice Rosen said earlier, there was no secret here. They knew what they were there for. And this, as your opponent stated, was just a summary way of saying what they were all there for.
If that's true, then I should be able to summarize in a felony murder case and say what you're really here for is to determine whether or not he's going to serve the rest of his life in prison or not.
But the felony murder case, the jury isn't going to make a sentencing decision. And here they're making a sentencing decision. Even though they don't impose the sentence, they make a recommendation on which is found.
Your Honor, I guess that's my disagreement. I don't think the jury makes even a recommendation about the sentence. The legislature has said upon certain findings, there will be a sentence, just like in a felony murder case. I think they're exactly the same.
Distinguish the argument that counsel made about during the guilt phase aspect of any crime. It's jurors, you're here to find whether the defendant is guilty or not of crime of whatever he's being prosecuted for. What's different about that than saying you're here to determine whether he gets 50 years?
In fact, when we give, I think, an instruction in every criminal case probably in Kansas, the instruction that says your only concern is to determine whether or not the person is guilty or innocent. Disposition of this case is a matter for the court, just like it was still in this case. And again, it seems like you have to choose one or the other. Are we going to inform juries or not? Because juries, even in this case, the jury does not impose or even recommend a sentence. The jury's job, why did you remand this case? So that they could make a finding on the elements in this case of whether, because they're elements effectively under a lien, of whether there were aggravating factors. That's the jury's only job. It has an impact, but so does every jury making a decision in every criminal case in this state. Thank you, Your Honor.
Thank you, counsel. We thank both of you for your arguments this evening. The court will take this matter under advisement.